Turning to Ronald Hargrove.
Jonathan Baber on behalf of Mr. Hargrove.
All right. Is Mr. Hargrove here?
I do see a Ronald Hargrove name. There we go.
Okay.
George.
I think I just heard him. He's coming on. All right. Okay,
Thank you,
Mr. Hargrove. Go ahead, Mr. Baber.
Yeah, today is the date and time set for a couple of things. It's a status conference, Judge, but it's also a hearing date for my motion to withdraw. I'm really just going to rest on what I put in my written motion for this court. I really can't disclose too much more in regard to what the conflict is between me and my client without risking attorney-client privilege, and I don't want to waive that on behalf of Mr. Hargrove. But I do believe there's been a breakdown in the communication between me and my client. We just aren't seeing eye to eye on certain aspects, and I want to respect his wishes on how he wants to have his case represented. So therefore, I'm asking this court to consider withdrawing me from the case.
All right. Mr. Hargrove, well, first of all, Mr. Baber, you are appointed to represent him. Is that correct?
I am.
I do see that in your motion. Okay, give me just a second to.
And I want to stress to the court too that Mr. Hargrove has been very respectful. It's just a situation where we just do not see eye to eye on certain things.
All right. So, Mr. Hargrove, you understand what, without getting into details, because I've read the affidavit of Mr. Baber, but do you understand what he is saying?
Mm-hmm. Yes, sir.
All right. Now, if I allow him to withdraw, which is what I'm leaning towards right now, I'm not sure whether there will be another attorney appointed for you or not. I don't know.
No, I was just confused about a bunch of things.
Right. But, when there's a significant disagreement as to how to proceed, an attorney cannot go ahead and present something to the court that the attorney believes is not justified by law or fact, even if his client thinks it is. So he can't do that if he believes that's against the rules that we have to practice under.
Okay. Well, let me ask you a question.
But you can ask it. I'll answer it if I can.
Are you the trustee for the Cesta KV account, Ronald Gene Hargrove II, or any account thereof?
I do. Sovereign citizens genuinely believe that if they declare the judge the trustee of their imaginary SSQV trust, they've magically created a conflict of interest that forces the judge to recuse themselves. It's one of those pseudo-legal fairy tales they love. Lots of buzzwords, zero reality. So, to give you the long explanation in the shortest way possible, no, the judge is not your trustee. Never was, never will be. And no amount of sovereign citizen word salad is going to make it happen.
You don't know
I
what I'm
suspect the answer is no, but we're really not going to go down that road. Right now, the only question is whether or not Mr. Baber should be your attorney or not. He's filed a motion to withdraw saying that he can't, basically you have a disagreement on how to proceed. That's too significant for him to proceed.
Okay.
All right, so I'm going to allow him out. Mr. Baber, was there an order that accompanied your motion?
No, Judge, I will prepare one and present it to the court by tomorrow.
All right, that's fine. I'll go ahead and sign that. Mr. Hargrove,
Yes, sir.
you wish to have another court-appointed attorney?
No,
Or do you want to represent yourself or hire your own attorney?
well, I guess I'm not going to get anywhere. No, my questions aren't being answered. So I don't know what to do.
Well, I need an answer. If you want to request another attorney, I can have you interviewed again by MIDC. They may or may not appoint an attorney for you or allow one. What do you want to do?
Well, um, I guess I'll go forward with an attorney, and
Okay,
because
so here's,
I have a witness and some other things.
Okay.
I guess I need an attorney.
There's no guessing needed here. You sound like you grew up chewing on lead paint chips for breakfast. And honestly, based on how you're talking, I'd bet good money you'd struggle just to serve a subpoena, let alone present any actual evidence on your own behalf. That's exactly why it's in your best interest to stop firing every attorney who tries to help you and start letting the professionals do their jobs. Representing yourself might feel empowering in your head, but in reality, it's the fastest route to losing a case you never even understood in the first place.
I mean, it's up to you. I'm not necessarily going to appoint one for you. Ms. Parker, is Mr. Brown there?
Yes.
He is. He just popped on. Mr. Brown, this is a bit of a new one on me. I don't know if you heard it all. Mr. Baber was appointed to represent Mr. Hargrove. He withdrew because they had some disagreement on what should be presented to the court. And I've allowed the withdrawal. Mr. Hargrove still wants a court-appointed attorney. Does that have to go to Mr. Slough, or is he simply re-interviewed by you?
I don't necessarily know if he even needs to be re-interviewed unless things had significantly changed, as he did have a court-appointed attorney. So unless things have significantly changed, I don't think a withdrawal would require a re-interview. I think he would just have to be appointed another attorney.
All right, so we'll notify Mr. Gilo's office of that. Mr. Hargrove, that attorney would be appointed for you. You'll be given the name and number of that attorney. You should give them a call. Pam, if you call, or that attorney, would you also let them know that they want to call Mr. Baker?
I'll try to remember.
Yeah, okay, I get it completely. But Mr. Hargrove, I suspect that if this attorney has the same situation that Mr. Baber does, you may end up representing yourself or having to hire your own attorney.
Well,
Okay.
I wish you would just please answer my question.
Well, that's nothing that I can answer in a situation like this. The only question, you need an attorney, you've requested an attorney. If the next time you come to court, I won't be here because there'll be another judge. As my term ends at the end of this month, in about 10 days or so, 12 days. So any argument would be presented to them, but it has to be done according to the court rules that we're all bound by.
No, he doesn't, especially considering he's retiring at the end of the month and a brand new judge is about to take over his docket. Speaking of which, let me introduce you to Judge Hesselink. He took over Judge Cooper's bench barely a month ago, and he's already been blessed with his very first sovereign citizen window licker. Now, this time our hero actually showed up with a lawyer, but somehow, someway, he still manages to spectacularly sabotage himself at every turn. It's honestly impressive how consistently he digs his own hole deeper.
All right, Ronald Hargrove, file 24-43189-ST. I see you, Mr. Hargrove, on Zoom. You represented by counsel, Mr. Hargrove?
I represent Mr. Hargrove, Judge.
All right, thank you.
What we're going to ask the court to do is accept the plea to count one with the second offense dismissed.
Mr. Fortier, is that an accurate statement of the agreement?
I don't know yet, Your Honor. I can't find the case for some reason.
All right, I'll give you a second.
Mr. Gilo, did Miss Brooker email you that offer?
Yes, on the 9th.
Okay. Then, yeah, Judge, that would be what we're gonna do then.
All right. Mr. Hargrove, you've heard the attorneys talk that there's an agreement being offered to you that if you plead guilty to the first offense of operating with your license suspended, the notice for second offense, which enhances the penalty, would be dismissed. Is that what you want to do? You're on mute now, Mr. Hargrove. You're going to have to take your, there you go.
She
Is that what
muted.
you want to do today? I'm sorry.
I just had a few questions.
Well, you're going to need to talk to your attorney about those questions. Do you need some time to do that?
He can't answer them for me.
All right. Well, then what are your questions? Let me see if I can answer them for you.
Okay, well, I don't understand how you can be the trustee of my SESTA KV account, Ronald Gene Hargrove II, and not have my best interest.
I'm sorry. What? I don't understand what your question is.
How can you be the trustee of the SESTA KV account, Ronald Gene Hargrove II, and not have my best interest?
What is that account that you're referring to?
Oh, God. The SESTA
Yes,
KV
he
account
is, but
that
Go
everybody
ahead.
most people have, and you're the trustee. Just like the Secretary of State is trustee of it.
And neither is the Secretary of State. Now, this judge may be fairly new to the bench, but he's handling this oxygen thief surprisingly well. He's calm, composed, and not buying a single ounce of the nonsense being shoveled in front of him. So I guess that means it's time to ask the classic 93-day question, the one every sovereign citizen eventually has to face. Has a sovereign citizen ever won a case using their magical Huffleduster word salad arguments? Spoiler alert, the answer has never been yes.
Not that I'm aware of.
Uh-oh.
Why would I be your trustee? Mr. Gila, do you have some additional information that I'm not picking up on?
No, Judge.
It's just something that I believe in, and I've seen evidence of, and
What leads you, Mr. Hargrove, what leads you to believe that I'm your trustee?
because of a former case I've seen.
A former case? What former case are you referring to?
In Roscom, and a friend of mine asked the judge that, and he couldn't answer him. So,
That's probably because it's not factually true.
well,
What information do you have that leads you to believe that I'm a trustee for you?
in that case, the judge quit 6 months into his new term because he was dishonored.
Sheriff citation absolutely needed here, because I'm going to need hard proof, real proof, before I believe that some backwoods sovereign citizen magically discovered a get-out-of-crime-free loophole so powerful it supposedly got both a judge and a sheriff fired. These people spin fantasy stories like they're auditioning for a Netflix series, but until I see documents, dates, names, and an actual verified case number, I'm treating it like every other sovereign citizen bedtime tale. Pure fiction with a sprinkle of delusion. Hamad? Hamad. Well, thank you for that, Judge Hesselink. You've barely been on the bench for a month, and you're already out here finding creative new ways to ruin Christmas, Easter, and every holiday in between for gullible, self-inflicted disasters who genuinely believe their nonsense is going to work in a courtroom. Impressive efficiency, honestly. Most judges take years to get this good at shutting down sovereign citizen fairy tales. You're speedrunning the whole experience.
So,
Mr. Hargrove, the question was not about a Roscommon County case. It was about this particular case. You've alleged that I'm your trustee. I'm asking what information or proof that you have that is true.
so you're just denying it?
I don't know of any information that it makes it true.
Okay. If it was
What information do you have?
if it
I'm
was
sorry,
a
Mr. Hargrove, go
misdemeanor,
ahead.
if it was a misdemeanor, would it be true?
No. Misdemeanors and trusts have nothing to do with each other.
Okay,
There
well,
has to be some court order for me to be a trustee for you. For anybody to be a trustee, there has to be a court order. Do you have such a court order?
no. I just believe that you are my trustee of the SESTA KB account, Ronald Gene Hargrove II, and that's.
Could you speak a little more clearly and tell me what that account is?
I'm not sure. I just believe that you are my trustee, and if you deny it, then you deny it. Okay, we'll move on from there. I guess You know, and another thing is I paid $1,000 for a reinstatement fee, but you guys keep saying I don't have a license. And where did my $1,000 go? I don't understand this.
Who did you pay
paid
$1,000 to, Mr. Hargrove?
the Secretary of State or the
Then you
state
need
of
to ask the Secretary of State.
Well, I believe I have my license, and they just keep. There's a screw up somewhere.
Then you need to contact the Secretary of State, but I'm not connected to the Secretary of State. I'm the court system. I work in the court system. I don't work for the Secretary of State, so I can't tell them what to do. If you believe that you paid the money and you should have a license, you need to contact the Secretary of State.
Well, knowing that I think I had a license at the time, doesn't that change things?
It would change things only if it were true, and I don't know that it's true. Just because you believe it doesn't make it true.
Now that I believe. All right, that wraps up this hearing. It's been rescheduled a couple of weeks out, and honestly, I can't imagine the next round being anything short of absolute chaos. If this was the warm-up, the sequel is going to be unhinged on a whole new level. Now let's move on to our next case. Here we've got a young man who swears he can prove his innocence with facts and testimony, yet refuses to take any help from the public defender. He claims he has everything under control, but judging by how quickly he's unraveling, it's clear he's about to make his own life significantly more difficult.
Hargrove, your attorney has told me, and the prosecutor has agreed, that there is an offer on the table for you to plead guilty to operating with license suspended in exchange for dismissal of the second offense notice, which makes this a much more serious charge.
Okay.
Do you want to accept that today, or do you want to have some additional time to speak with your attorney?
No, they don't have nothing to say to me. Their best interest is of the court. So I'll take that, and I would hope to get the same fine everybody else did today. Thank you very much.
Well, I can't guarantee that because you're in a different circumstance than everybody else.
Well, I'm pleading guilty to the same offense they just pled guilty to.
But your background is not the same as theirs.
You know what? I'll plead insanity.
Yes, you absolutely have the right to defend yourself, just like you technically have the right to walk off a tall cliff onto a pile of jagged rocks. Doesn't mean it's a good idea, and I genuinely understand the position you're in. You believe deep in your heart that you're innocent and that you have all the proof in the world to clear your name. But here's the problem. In court, it's not enough to have evidence. You have to know how to properly submit it, argue it, and navigate the rules so it actually counts. Lawyers know how to do that because it's literally their job. They understand procedure, admissibility, deadlines, filings, objections, everything the court expects. That's why judges consistently advise everyone, even people who swear they're innocent, to let an attorney handle the case before ever suggesting they try to go pro se. Because the truth is simple. Innocence doesn't protect you. Procedure does. And if you can't navigate it, you're walking into a gunfight with a pool noodle.
Oh, you were up for an arraignment this morning.
Yeah,
that was at 8:30.
Yeah, I dropped my son off at 8:30. I didn't know because the court didn't open.
Okay, so what we have to do,
so I'm trying to figure out how to get it.
Well, I don't think you're
going to.
You're not going to. I don't think you're going to. Are you going to have time to address that? You want to go through an arraignment?
Please. That's fine. Thank you.
Then you go discuss it with Mr. Sierra.
We talked.
What's that?
We talked.
You already talked? All right. Well, let me finish.
Form's already submitted.
Okay, let me take care of these here quick, and I'll get right to you. Let's go in the record in the matter of the People State of Michigan versus Brown, file 2444177FY. And state your name, sir.
Quentin Brown.
Assistant Public Defender Dario Sierra appearing on behalf of Mr. Brown for the purpose of arraignment.
Very good.
We have reviewed that felony file. I waive reading at this time. I'm speaking with him. He has asked that it's set for the probable cause conference in the prelim. After he has just advised now that he would like to self-represent. So court-appointed attorney is being denied by Mr. Brown.
Well, it's not being denied.
It was previously
declining
granted,
to accept it.
so
All right. You sure about that? You want to represent yourself when someone goes to school for many years to learn how?
But I know what's going on better than anyone that can.
I know it's a little hard to make out, but it sounds like he's complaining that his defense attorney received a plea offer from the prosecution, not accepted it, just received it, and then passed it along to him for consideration, which, by the way, is literally the attorney's legal obligation. He seems to think the public defender secretly agreed to a plea deal behind his back, when in reality, all the lawyer did was what every defense attorney is required to do: relay the offer, explain it, and let the client decide. But as you're about to see, that's not the only thing he managed to misunderstand. This is just the first stop on a long road of confusion.
And the prosecutor makes what is known as a plea deal or a plea negotiation. They have a responsibility. They have ethical responsibility to share that with you. That's your decision, But they have to present it to you, at least for you to make that decision. But when I appoint an attorney to represent you, you're that attorney's boss. And if you decline a plea negotiation, then it's declined. That's up to you, not to them. So, like I said, I'm gonna go ahead and indicate here that you wish to represent yourself. That's fine if that's what you want, but I would be thoughtful about that, because again, this is what they do for a living. You know what I'm saying?
Well, I know in court that they had to find me beyond reasonable doubt, guilty beyond reasonable doubt.
That is
true. I feel comfortable representing myself because I know for a fact I'm innocent and I haven't committed any crimes.
Okay. Well,
But
that's fine. We can
anybody else you can represent me, they don't know. They don't know.
Well,
100%.
But
they can go home and sleep and be like, they don't know me.
Okay.
They don't know.
All right.
If I did these things.
Here's the thing. What happens though at a trial, if you're representing yourself, and again, the end result of this is you're going to be able to represent yourself if you want, but it's going to be not you, it's not going to be a judge, and it's not going to be the prosecutor that makes a decision as to whether or not you are indeed guilty. It's going to be a jury.
I know.
And they're going to have to, and
it can be you.
It's not going to be me.
Or whatever it is. I guarantee you will be changing this verdict after I got what I got to say.
I would be legitimately surprised if I found out that he tied his own shoes this morning without verbal instructions from Alexa.
I'd honestly be shocked to learn he tied his own shoes this morning without Alexa walking him through every step like a preschool tutorial. And this right here is exactly why this man should not be representing himself. He doesn't understand the most basic concepts of a trial. The verdict is the final decision made by the judge or jury. It happens at the end of the trial, not at your arraignment, not in the middle, and definitely not whenever you randomly decide the process is over. So if he's over here claiming he's going to overturn his verdict by the end of the trial, all he's really doing is admitting he expects to lose, even with all this supposed exonerating evidence he claims to have. And if you're already predicting your own defeat before the trial has even begun, that's just further proof you need an attorney. Because the only thing you're winning on your own is a front row seat to your own conviction.
And I don't know what your evidence is, but the thing is, if you have an attorney to assist you, that helps you get that evidence in, because there are some things that cannot be brought into court, and they know those rules. I don't know if you do or not. Maybe you do, but if you do, that's fine. But there are some things that cannot be brought in, things that are considered hearsay, things that don't have a proper foundation, things that may not be authenticated.
Well, cash, like you paying me on the table.
Mr. Bob, you're on the record right now.
I don't want you making any statement, sir, that is going to incriminate yourself.
It's not going to incriminate you, sir.
Anything you say though, sir, can be used against you.
Exactly.
This is a court record.
Yeah, exactly. I just don't want anything.
I wouldn't do that in court. I'm in